SJC-11545, Massachusetts State Automobile Dealers Association, Inc., et al., v. Tesla Motors, Massachusetts, Inc., et al.
Let's proceed. Good morning.
Good morning, Chief Justice Ireland and justices of this honorable court. May it please the court, my name is Thomas Van Gel, and with me is my associate, James Radke. Together, we represent two independent Massachusetts motor vehicle dealers and the Massachusetts State Automobile Dealers Association. The issue before this court today is whether standing under Chapter 93B, Section 15A, for a motor vehicle dealer to assert a claim against a manufacturer for unlawful ownership of a dealership in violation of Section 4C10 is limited to a franchisee of the offending manufacturer. The literal language of Section 15A provides standing to any motor vehicle dealer, manufacturer, or distributor that suffers any loss of money or property as a result of a violation of Chapter 93B, or who can establish a substantial likelihood of such loss if not enjoined.
But we know, I'm sorry.
Go ahead.
But we know that standing is not determined solely by the literal language of the statute. And we know that from any number of cases, including Beard, which construed the predecessor version of this statute. So that's not dispositive. And we also know at least what the purposes of the old statute were, and that they don't include protecting dealers from interbrand competition, and they don't protect the business model of franchisees, including dealerships. That's not within the area of legislative concern of the pre-2002 statute. So it seems to me that what you have to do is show how it is that the new version, the 2002 version, expanded the purposes of the statute. And, you know, it seems to me that in your briefs, you're doing that solely by reliance on the language of two minor changes. One being the standing to include manufacturers and distributors, as well as dealers, and that the language that says that a manufacturer may not own or operate a motor vehicle dealership of the same line or make.
Justice Lenk, I would respectfully disagree that it was a minor change to the statute when the legislature eliminated the relevant market area requirement that was in 4C10. That was a significant change that was made to the statute, and that is what, in fact, enacted a complete ban on factory ownership, whereas before, a manufacturer could own a dealership within the Commonwealth of Massachusetts as long as it was not within the relevant market area of another dealership. That was a significant change, Your Honor.
Couldn't you view the change as because the relevant market area determination was so complex and so cumbersome in determining whether or not a dealer had standing to challenge its manufacturer, that this is simply a way of allowing dealerships to challenge so long as they can show. I mean, a Ford dealer in Springfield could challenge Ford, the manufacturer, for opening up a dealership in, I don't know, Cohasset, if they could show that they were harmed. But it's just a different way of getting at, you know, who's within the range of harm under the purposes of the statute, that is to protect dealers from oppressive power of their manufacturers and distributors.
Justice Lenk, this is one area where the Superior Court made a mistake. They interpreted that the removal of the relevant market area requirement was because it was a confusing requirement, it was a complicated requirement. We don't dispute it was confusing and complicated, and because of that, the MSADA came up with a simplified approach that was specifically adopted by the legislature. It's contained in Mr. Okaneski's position paper, which I'll speak to later, as a way of simplifying what was a very cumbersome process for dealers. So relevant market area was alive and well as a concept in the new statute. And what the legislature did was they made specific definitive mileage requirements. So if you were a dealer in Suffolk County, it was an 8-mile radius that constituted your relevant market area. If you were a dealer in Barnstable County, it was a 10-mile relevant market area. So the notion that the legislature's elimination of relevant market area was only because it was complicated and confusing just isn't the case. That
Frankel?
isn't.
Oh, sorry, I'll let you finish your sentence. I'm listening to, I think you're reciting something that comes out of a position paper. Why would we care about the position paper? It hasn't been shown that it was something that was within the contemplation of the legislature, has it?
Well, it had, Your Honor, there was an affidavit from my client who's here today that was submitted to the Norfolk Superior Court. He was then the Director of Government and Legislative Affairs. He's now the Executive Director. He submitted that to the Legislative Committee considering the bill. The MSADA was championing this bill. They wrote the bill. They presented it to the legislature. They got it sponsored. And in that position paper, and I would direct your attention, I would direct the court's attention to the appendix 510 to 515. Paragraph 4 of the position paper specifically states that one of the key provisions of the amendments is to eliminate loopholes to existing prohibition on factory store ownership. The position paper specifically referenced virtually the identical situation we have here with Tesla as a loophole that would be eliminated if the legislature enacted that first sentence in 4C10, which remained unchanged from when the bill was first submitted to when the legislature enacted the bill. And in his position paper, Mr. Okaneski stated to the Legislative Committee, loophole number 2, and this is in paragraph 4 of the position paper, about 4 pages in to the appendix, around 513. Loophole number 2, no same line make dealer exists to challenge a factory site of a dealership for its new division. That's the situation we have here. There is no other Tesla same line independent dealer. There is only one non-independent factory-owned dealer. So no one had standing under the prior statute to contest that. The reason for the enactment of the first sentence in 4C10 was to eliminate this loophole. And the position paper goes on to state that the amendment would eliminate this loophole as to explicitly prevent factory ownership or operation of dealerships and prohibit the direct sale of new cars to consumers by the factories.
Other than this position paper, is there any legislative history that supports that the legislature was in fact trying to, what you say, close a loophole, which would suggest that somehow the purpose of the statute had been expanded to protect dealers from interbrand competition? Because that's the only thing that would be achieved by that.
Your Honor,
What difference would it make to, I mean, ordinarily, the statute is construed as protecting, having dealers, a Ford dealer protected against Ford or a Ford distributor. That's the way it has been construed in the past, to protect against oppressive behavior by manufacturers against their dealers. If this were to be construed as you're construing it, it would mean that Ford could bring suit against Tesla.
yes, and they
And that
could,
would be
and-
interbrand competition that has never been seen as one of the purposes of this statute. And so I guess what I'm saying is that's a major change in the statute that you're suggesting is happening. Where do we find that change in purpose in the statute or in the legislative history?
Well, I think this memo is very clear, and this is from the organization that was spearheading the effort that drafted the legislation. I don't know what could be more persuasive.
Have you got any cases that have ever had us rely on something like a position paper to show what legislative history was?
Well, last month, Your Honor, in the Sheehan versus Weaver case, the court indicated that it may enlist the aid of reliable guideposts in construing the legislature's intent. And I would strongly urge, suggest to the court that this position paper is clearly a reliable guidepost. We have the organization that wrote the bill presenting it to the legislature. The legislature substantially amended Chapter 93B. They adopted most of the recommendations. There were some eliminations of language, but with regard to 4C10, in this provision that we're talking about, the first sentence, that remained unchanged throughout the process.
Was there along your lines, do you know, was there like State House News, was there hearing on this?
There were several hearings
So
on
there
this bill.
would there be some legislative discussion? I understand what you're saying, and I'm just wondering if there's anything in an expansive view of legislative history, but that you know of, that indicates legislative comments on this particular memorandum that was submitted.
There were extensive hearings and discussions with the committee. The issue was, unlike when the bill was first adopted in 1970, there was not a legislative report being commissioned because this bill was being sponsored by an outside organization. So we
Meaning
don't have
your client.
my client. We don't have an official report from a legislative
No, it wasn't
committee.
official. I just wondered whether there was, as there
Your
often
Honor,
are, State House News
there were
reports and stuff.
There were extensive hearings on this bill in meetings with the legislative committees because the process started sometime in 2000. This memo was 2001. The amendment was enacted in 2002. But Justice Lank, I'd just like to go back to the point about the franchise system. The manufacturers in this country were able to succeed in selling vehicles to consumers through dealers in Massachusetts. That's the way it's been done. That's the way the statute provides in 93B. And in Massachusetts, in order to sell a vehicle, you need to get a license under Chapter 140, Section 58 and 59, a Class 1 license to sell new motor vehicle dealers, to sell new motor vehicles. So not anybody walking off the street can sell a new
I
motor
appreciate that.
vehicle. And that concept is incorporated into Chapter 93B. And
But the question is really, you flipped it. It seems to me that the legislation, according to the cases that construe legislative history of the former version of the statute, suggests that what the statute was there to do was to protect people, dealers in particular, in a system that was already in existence. It wasn't so much an endorsement of the system as it was a way of protecting people who were already in those relationships and regulating those pre-existing relationships. It wasn't so much endorsing it and saying that's the business model that we have to have.
I would disagree, Your Honor, because today, you look at the language of the statute is clear that no manufacturer shall own a dealership. The issue is one of standing.
Only a
The language-
dealership of its own. A manufacturer can own a dealership.
Correct. And the reason for that is this. There is one significant distributor in Massachusetts who happens to own several other dealerships. Had there been a ban on factories owning dealerships of vehicles they don't manufacture, this distributor would have been disqualified.
Which is that?
This is Subaru of New England that's owned by the Bach family. And just in terms of legislative history, they waged a formidable battle in the late 1990s to the effort to amend the statute then. The MSADA came back and in 2002 was successful. So they were significantly interested in this issue, and the manufacturer ban and the distributor ban on operating dealerships of vehicles which they manufacture or distribute exists today. So there's a very limited exception for manufacturer, distributor-owned dealerships. Only those dealerships which sell vehicles they don't manufacture or distribute. And I think that's telling in terms of the legislature's intent. Another way to look at this is, why would the legislature create two classes of manufacturers? one with independent dealers who can't sell directly to consumers, and another class of manufacturers who can sell. It's an uneven playing field. It creates unfair competition. It just doesn't make sense that the legislature would intend this result.
Even if you are correct with regard to what you contend, you would still need to show, in order to obtain standing, that the plaintiff suffered a loss of money or property.
We actually, remember, Justice Gantz, this was decided at the
Right,
injunction
so
level.
you may get past a motion to dismiss because you've alleged a loss of money or property, but at some
Correct.
point in time,
Correct.
that would need to be an element of your claim.
Correct,
Now, with regard to associational standing,
yes.
how can the association, which concludes all sorts of dealerships, be in a position to claim as an association that it suffered a loss of money or property? I mean, it's going to be a little bit hard for a Kia dealership to say that the presence of a Tesla dealership is causing it competitive harm, and you represent a whole set of dealerships, Lexus, Kia, the whole range.
Well, there are a couple of concepts, Your Honor. One, with organizational standing, associational standing. Obviously, the dealers have, let's assume the dealers have standing
they
under
have
the
standing.
statute. If they have standing, then the organization has standing, because the issue is obviously germane to the MSADA's purpose, and the individual claim isn't necessary. The MSADA isn't precluded because there's common harm, because of the issue I just raised, creating two classes of manufacturers. You're creating unfair competition that
But,
eventually,
but
what's going to
You'd have to
happen?
prove, you'd have to show it. You can't merely contend that that the rest of us are under obligations which Tesla is not. That would not be enough by itself, I would think, to show a loss of money or property. You'd have to prove it.
Tesla concedes that under their model, they achieve significant savings, so they can sell a comparable vehicle to another manufacturer at a lower cost. So as a
Counsel,
result,
you know, I have to insert myself. You're 2 minutes over. Your time is up. Thank you.
Mr. Chief Justice, members of the court, my name is Richard Campbell. I'm here on behalf of Tesla Motors, Inc. and Tesla Motors Mass, Inc. I'll refer to them collectively as Tesla, just for ease of discussion.
Mr. Campbell, if you just looked at this statute, no history, statute just enacted, brand new, you looked at section, what is it, 10, subsection 10, 4B.
4C10.
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 I mean, doesn't it read pretty clearly that a manufacturer simply cannot have a dealership in the same line of cars that they manufacture?
If you look at section 4C, you will find 12 subsections, 12. Each of those 12 subsections deal with the relationship between affiliated dealers and the manufacturer selling product to them. Section 1 deals with arbitrary and unfair allocations of new vehicles to dealers. Section 2, failing to disclose the methodology for allocating vehicles. Section 3, refusal to deliver reasonable quantities of vehicles in a timely manner. Section 4, coercing agreements by threatening termination. And each one of those sections all relates to the relationship between a dealer and its affiliated manufacturer. Turning to 4C10 and your question, Justice Cordy, 4C10, if one looks at the sentence itself and the incorporation of the language same line make, then one could conceive that that is ambiguous. You have to figure out what is that phrase doing in the context of that sentence. If the
Same line make is the same line of cars.
So if the purpose is, as the plaintiffs suggest, that the legislature intended to prevent a manufacturer like Tesla from selling vehicles in the Commonwealth,
That it manufactures, the same line that it manufactures.
it would then have ended that sentence at 4C10 with the word Commonwealth. The rest of that, half of that sentence, all of those terms would be mere surplusage. They would have no meaning.
Wait,
And
I don't understand what you mean.
if Your Honor takes a look at the statute,
Yeah.
the section in question, give me a moment, and I'll
To own or operate either directly or indirectly through any subsidiary, parent company, or firm, a motor vehicle dealership located in the Commonwealth, and you say we should end there, as opposed
Yes.
to going on to say, of the same line make as any of the vehicles manufactured, assembled, or distributed by the manufacturer or distributor.
If the purpose was to prevent a manufacturer like Tesla from selling its vehicles in the Commonwealth of Massachusetts, the purpose would be achieved by ending the sentence at the word Commonwealth.
But it doesn't, the statute was never intended to prevent Tesla from selling Studebakers.
No one could read that statute, I guess, to suggest that Tesla could purchase a dealership from Ford or Chrysler or General Motors, set up that dealership and run it. That would not make any sense, would not square with
Make
the
any
way the world.
economic sense, but it would make sense. I mean, I don't, isn't Justice Spina right, though? I mean, it's not,
One could read that statute, that sentence, so as to provide a manufacturer like Ford the opportunity to run a Chevrolet dealership across from a Ford dealership. And of course, that would not make any sense at all. If the purpose of the underlying core purpose of 93B is to protect dealers from abusive behavior by their affiliated manufacturers, and part of that purpose would prevent a Ford Motor Company or General Motors or Chrysler from opening up a competitive dealership across the street from an affiliated dealer.
But isn't your better argument the one that you first made, that if you've got to read Section 4C10 in the context of all the other subsections, and it's there's an organic whole here that refers essentially to the franchisees, a franchise system.
Absolutely, Your Honor. I went down that road initially trying to answer a question from the court, but if you step back and you take a look at the 2000 Act and the provisions of the statute, you would show that you would find, I submit, that they all deal with the relationship between a dealership and its affiliated manufacturer. The 2002 Act was entitled, quote, "Further regulating business practices between motor vehicle manufacturers, distributors, and dealers." And then in Section 5 of the Act, it states that the Act shall apply to all franchise agreements existing on or after the effective date of the Act, and then specifically incorporates by reference 4C10.
But I mean, you're in violation of, I mean, isn't Tesla right now in violation of 4C10? You are a manufacturer. You are operating directly or indirectly through a subsidiary, a motor vehicle dealership in Massachusetts, and you're involved in selling cars of the same line that Tesla manufactures.
Most respectfully,
Isn't all that true?
most respectfully, Your Honor, first of all, that issue is not before the court, but more importantly, the
Okay,
proper...
well, isn't it, can't they allege that it is true? I mean,
They
they're
have
alleging it's true.
they have alleged it's true,
And if
yes.
it's true, it's a violation of 4C10.
That does not address the question of whether the plaintiffs have standing, because they have to have...
Okay, I'm not speaking of standing right now. I'm asking right now, have they alleged a violation
They have
of
alleged that
4C10?
violation,
So
yes,
if they are correct, Tesla is in violation of 4C10.
If you ask me to assume that they are correct, then they...
Okay, so
way you
if
posit the
it
question.
is correct that what they've alleged is a violation of 4C10, then who, if not them, can enforce the prohibition in 4C10?
The provisions of 93B for enforcement are allocated to the Attorney General's office. And in fact, the Dealers Association solicited the Attorney General in this circumstance to seek enforcement of the statutory provisions against Tesla, to no avail, I might add.
But what would happen if Tesla or some car manufacturer from, say, Eastern Europe, who's never done business here before, is starting to make cars, and then they open up 15 showrooms across the state, and they start selling their cars. No dealerships, but it's their own showrooms in 15 cities across the state. There would be all kinds of consumer protection statutes that are currently enforced by the Attorney General's office involving dealerships that would go completely unenforced.
No, I don't think that's correct, Your Honor. I believe that the statutes and regulations related to the sale of motor vehicles would pertain to the manufacturers in your hypothetical
They'd
that
have to get a
pertain to
license.
Tesla.
They'd have to get a license, right?
Exactly right.
Be regulated under the statute as any other dealer, but it would be a
That's
manufacturer-owned dealer.
correct. In order, and I'm sorry to cut you off, Justice
sorry.
Corder, but that's correct. In order to sell motor vehicles, new motor vehicles, under our statutes, one must get a Class 1 license, which Tesla has done, has obtained.
You say the Attorney General is the one who can enforce this, but Section 15A creates specifically a private right of action, right?
Yes, it does.
And it says that any manufacturer, distributor, or motor vehicle dealer who suffers any loss of money or property as a result of an unfair, deceptive act or practice as defined in this chapter. So then I go back to 3, which defines unfair methods of competition or deceptive acts or practice, and it turns you to Section 4, and Section 4C10 is one of them. So I don't know why you say that there isn't a private of action.
There is a private right of action, first and foremost, if the plaintiffs can prove injury in fact.
Well, that's
which,
fine, right, but that's not, but we're outstanding right now. If they can prove it, I agree with you.
well, they initiated this action by means of an order of notice and convened a hearing on an application for a temporary restraining order and preliminary injunction. At that hearing, their obligation then was to prove injury in fact, and to the extent that they were looking for injunctive relief, to prove a substantial likelihood of success on the merits and substantial injury as part of it. There was never any proof, no proof whatsoever of any injury in fact, no proof whatsoever of any substantial injury in the future. All that was proffered by way of rhetorical allegations at that stage of the case, all was that Tesla, in operating the Natick Gallery showroom at the Natick Mall, was violating Massachusetts law. That was the primary allegation at the time. In terms of injury, in fact, the only assertion was some vague assertion about confusion in the marketplace. Judge Fishman, at the hearing on the preliminary injunction, specifically asked the plaintiffs, have you sustained any injury in fact? And the answer was no, they had no proof of any injury in fact. Judge Fishman then asked, do you have any proof of injury that would warrant injunctive relief, any injury in the future? And the response to that was, and you'll find this in the record, the response was that the blogs were going wild with comments about Tesla, hoping that Tesla would prevail in the lawsuit and bring about a change in the distribution system for motor vehicles. That was the only proffer made when of so-called proof at the Superior Court in front of Judge Fishman.
Are you suggesting that we should not interpret Section 4C10 and just say you have an established injury, you don't have standing, we're not even going to get into 4C10 and say what it means, what we think it means?
The answer to that is yes. I think the jurisprudence of this court requires the plaintiff to prove that they have injury within the context and concern of the statute.
But if we conclude that the statute means essentially what the dealers say it means, then they are much closer to having standing than not. We conclude it means what you say it means, there really is no standing because it hasn't really changed the zone of interest.
And I submit, Your Honor, it has not changed the zone of interest. This statute was created on a substantial record and history of abusive conduct by manufacturers, the big three manufacturers, toward affiliated dealers.
But that was
I
the old
understand that, but
version.
that's the old version.
But don't we really have to concern ourselves with what happened in 2002, not what happened when it was first enacted?
Yes, Your Honor asked pointedly, is there any legislative history to support the proposition from the plaintiff? And the answer to that is no. There is no legislative history. If there were real legislative history, it would be before the court.
Do you disagree with what your brother said, that in fact the bill was proposed by his client?
I don't disagree that the Dealers Association in 2001 proffered materials in relation to proposed changes to the statute. I don't. In 2001, Senate Bill 87 included specific provisions that would have, at least in 3 instances, would have prohibited direct sales of motor vehicles by a motor vehicle manufacturer, including the obligation, the prohibition of obtaining a Class 1 license. That was one of the provisions in Senate Bill 87.
But was were the statutory amendments that went into effect in 2002 precisely the recommendations or the requests that have been made by the Dealers Association?
I can't answer that, and I don't believe that anyone can answer that
Well, you can
on the
compare
basis
what
of
they-
this record.
Okay.
The talking points memorandum, which was submitted as part of a motion for reconsideration in front of Judge Fishman, was rejected by Judge Fishman as hearsay. There's no evidence or proof that that document ever either was presented to the legislature or considered by the legislature. There's no reference in the legislation or from the legislative.
Brother says there was an affidavit.
An affidavit in the Superior Court at the hearing, not at the hearing, after the hearing on the application for preliminary injunction. That's how the talking points were presented to the Superior Court. My point, Your Honor, is that there is no documentation record that material was ever delivered or really considered or evaluated or put into use by the legislature in any fashion whatsoever.
Did the manufacturers or any of the manufacturers, your client or to your knowledge, other manufacturers have any input into this? Were they aware of this bill passing through the legislature, and did they submit oppositions or papers on it?
I'm quite convinced Tesla did not, because it didn't exist. As to the legacy manufacturers, the big 3, I have no idea whether General Motors, Ford, Chrysler, Toyota, or the others took any position with respect to this. It seems to me it would be likely they would have. This 93B is really directed at the relationship between affiliated dealers and manufacturers. I would envision that they would have submitted something, but
Not your client, understood.
well, some of them are my clients, but not in this case, not in this matter. My time is up. Let me just end by saying that there's nothing in the legislative purpose behind 93B that was intended to suppress competition or to stifle innovation in the way in which motor vehicles are distributed. In fact, if you look at 93B, Section 6, subparts G and 8, the legislature stated that increase in competition is in the public interest. Increase in competition is in the public interest. That's what Tesla is striving to do, to compete in the marketplace, to give our consumers, our citizens, choice. And the dealers are trying to prevent that competition and prevent that choice. Thank you.
Thank you, counsel.